Gosh, I'm glad I didn't wear a suit. Okay, this is like my trendy outfit. I'm wearing jeans, imagine that. So yeah, my name is Kelsey Farish, and I'm here to talk about generative AI and intellectual property rights from the perspective of me, a media lawyer. So I've always been really passionate about the creative and the performing arts. Passion is the theme for this session today. In fact, I think if you spoke to my parents, they would say, Kelsey got lost on her way to drama school and ended up in law school instead. So, but it's okay because I can still be on a stage as a lawyer, so it all works out. I have been, because I'm so passionate about the creative and entertainment industries, I thought, how can I get really close to the subject without actually being on stage? I'll be a media lawyer. So today, that requires, of course, a really strong understanding of digital media, brands, reputation, publicity, and so on. So I'm one of the few experts in Europe who's actually been writing about deepfakes and generative AI since they really crashed onto the scene in 2017. Not even my husband has read my peer-reviewed papers on publicity and brands and using AI-generated actors, so I don't expect you to, but they're out there. So yes, I'm an expert. I've been on the news, BBC, street cred established. Bit of a health warning. In the same way that a doctor can give general advice on nutrition or not smoking, but they can't give you an official diagnosis or a treatment plan, I'm a regulated professional, and my boss, my law firm, would be very upset if I proposed to be giving you all official legal advice. That said, if you do want to chat with me over coffee, I'm not going to charge you for it, no obligation, just come find me. You can DM me, write me an email, whatever, just grab me during one of the breaks, and I would be very happy to discuss any specific questions that you have. All right, so Nathan gave us some amazing examples of what generative AI algorithms can do, but I thought it would be useful to actually pause and look at some of the very basics, because before we can discuss the legal issues, we have to understand what actual copying is going on. So we have here some training data, some selfies, some screenshots. I'm going to show this to a artificial intelligence algorithm called a generative adversarial network, or a GAN. The GAN is going to learn the color of my eyes, the shape of my ears, how I like to wear my hair. And with a click of a button, it will then generate what's known as synthetic media over here. So really smart people, computer scientists figured this stuff out, and I talk about it from the legal perspective. In addition to creating brand new media like we've seen, we can also make some lovely improvements. For this selfie, I asked my GAN to use a beautifying filter. The GAN, because a computer programmer told it that full hair and fewer wrinkles equals beauty, poof, this is what I got. Now, it's important to pause here and say that there's an important conversation to be had about beauty standards, especially with regards to people of color and people with visible disabilities and so on. I'm not going to talk about that today, but I think we all have a responsibility to use AI responsibly and ethically. But again, we can talk about that later. This is really exciting tech. It's really cool, but it gives rise to a lot of questions. I'm not going to talk or read all about this right now, but there are things like who owns the copyright, what are the ethical implications, what legal liabilities we might face, is someone going to sue us, and what rights do we have versus generating things versus modifying, okay? So what we're going to focus on today, how can we protect our stuff from being scraped and replicated or modified by artificial intelligence? And also, flipping it on its head, who owns the copyright in the stuff that AI creates? People always joke and say, lawyers, they always say it depends. It's true, it does depend. And in this case, the ecosystem, the legal ecosystem that tells us what we can or can't do or what the risk is, it's really complicated. It involves multiple things. The key ones are on the screen here. IP, but also contracts, business relationships, publicity and privacy laws, online regulations, advertising. You all will be familiar with the CAP code and the ASA and so on. And these things are super complex because they're influenced by a lot of exogenous factors. trade customs, societal changes, the rise of online shopping and behavioral analytics, so cookies and tracking technologies like that impacted GDPR. That forms and shapes what we as a society think the law should or should not say. And of course, lawsuits. When a new challenge comes along, lawyers and judges have to figure it out. They need to go away and come up with new stuff. And then obviously, MPs and legislators and bureaucrats come up with regulations based on their own knowledge. All right, so in the interest of time today, we're just going to talk about IP and contracts, my bread and butter. Now, copyright. Everyone here, I assume, knows what copyright is, but I am going to break it down to a very simple level. I have here a beautiful artwork that my son made at nursery last week. He's 16 months old. I call this yellow paint on red paper. I will frame it, probably. This has copyright protection. Why? Well, it's creative. It's not a mathematical equation. It's not a list of phone numbers. It is a creative, artistic expression. It's also original. I know for a fact he didn't look over at Orlando, his little nursery friend, and say, oh, I want to make it just like Orlando's. No, he created this original. It's expressed tangibly. I can see it. I can experience it with my own senses. It's not an idea. It has been officially expressed. And indeed, although a toddler can be a monster, he was, at the time of creation, a human. Because my son Hugo has copyright in this, the law, even though he's a child, fun fact, grants him certain exclusive rights. What are those rights? He, and he alone, or indeed me, acting as his guardian, he can reproduce it, he can distribute it to the public. If it was a play, he could perform it. If it was a piece of music, he could perform it. He could also make adaptations based on the original. Why? Because the law thinks that artists, authors, and so on should be able to control their creative, intellectual labor and make some money. Okay? And of course, as you all know, we can buy, sell, trade, transfer those rights via contract, assignments, licenses, and so on. Oh dear, what do we have here? So this actually gives us our first issue. We heard a little bit about stable AI, stability AI. So AI systems like Stable Diffusion actually utilize copyrighted material in their generative adversarial network. We saw in my example early on. And this is blurring the traditional boundaries of what is meant by copyright infringement. What do we think? Is this a direct copy, or is it just been inspired by that? Is it transformative? Is it fair use? Is there an exemption? Is using this to train that any different from a photographer looking at the works of Helmut Newton and being inspired and then doing black and white semi-nude photographs of women for a fashion editorial? I don't know the answer to that question. Do note here the scrambled Getty Images watermark there, so it's pretty, pretty obvious that they used that. Stable Diffusion argues that, hey, they didn't do any of the copying, it was their algorithm over there. So no human actually committed any IP infringement. And until the legal system, so lawyers like myself and judges and so on, until we figure out how to utilize the tools that are currently at our disposal to answer this question, everyone's kind of stuck in limbo. We don't really know what's going to happen. I will say that just last night, the head of Stability AI's audio team quit. He resigned. He posted a public statement saying that he didn't agree with the fact that his company was ripping off copyrighted works. He asserts that it's not fair use. So go on X and see what is going on in that space. It's quite interesting. So the long and the short of this slide is, it depends. I don't know. It's an evolving space. I will be reading the lawsuit judgments once they come out, but they're still ongoing. Now, this leads us nicely to the next question, which is, who actually owns stuff like this? If we know that it's uncertain as to the extent that we can protect our original non-AI generated artwork, what about the stuff that's actually generated? Let's say I do want to use a piece of synthetic media for a fashion campaign. Can I do that? Am I allowed? We know that in order to have copyright attach, the piece of work needs to be original, creative, human-made. Obviously, it's tangible. And again, this is because there's some aspect of financial reward that 300 some years ago, Parliament decided that musicians should be able to make money off of their music. Why? Because what's written on a piece of music, on a piece of sheet music, is worth more than the paper and the pen used to actually create it. There was some intellectual labor that went into creating intellectual property. Generative AI flips this on its head. Is the art original, or is it just a remixed copy? Can AI actually be creative? Is it the algorithm that's fantasizing, that's dreaming, that's using, it's learning? Or is it the code that's sitting behind it? That brings me to the third point, human-made. People will look at generative AI and they'll say a machine made that and an algorithm made that. What is it, Skynet on a Terminator? Skynet made it. The Cylons made it. Other people would assert, to include Stability AI, that actually humans made it because human programmers were the ones that told the algorithm that full hair is a sign of beauty, or that Wedgwood ceramics are blue and white, or whatever the case may be, there is human input in there. And the fourth point is a policy point, and it's something that lawmakers today on both sides of the Atlantic are really struggling with. It's, do we really need to incentivize creators, computer programmers, photographers like Nathan? How much effort really goes into pushing a button on Midjourney? Sorry, I'm not, this isn't like, don't worry, I know a lot of effort. But he was stood up here saying, oh, it took 10 minutes. I'm not sure how long this took my son, but I'm sure, this gets copyright protection. This probably took him 2 minutes, right? The law doesn't really care how good the art is. It doesn't. We've been down this path before, no pun intended. This is an AI-generated piece of art. This is a case that comes from the United States. Stephen Thaler generated this image using an AI system that he created. And in his very own words, it was autonomously created by a computer algorithm running on a machine. So a recent entrance to paradise. Not really my style, but I would argue that it's perhaps more artistic and nice than my son's finger painting, okay? He wanted to say, I have got copyright ownership in this. And the US Copyright Office, which unlike the UK requires registration of copyright, boring. They said, no way. There is no way you get copyright protection in this, Mr. Thaler. You're a very clever dude, but no. Why? Because there was no nexus between the human mind and the creative expression. The law, and again, the copyright laws in the United States and the United Kingdom, as well as something like 184 other countries that are signatories to the Berne Convention, they're all pretty much the same. Copyright law cannot protect new works that are generated by new forms of technology, absent any guiding hand. Can't copyright protect that. Some of you might be thinking, well, that's a bit weird. Because we've been here before with photography, with the advent of photography. And one of my favorite US Supreme Court cases is Burrough-Giles Lithographic Company versus Cerrone of 1884. Why is this a great case? Because it proves in a legal sense that photography is indeed an art, it's a skill, it's a craft, and photographs deserve or are warranted copyright protection. So the story is this. This famous photograph of Oscar Wilde was taken by Napoleon Cerrone in 1882. Without his permission, the Burrow-Giles Lithographic Company then took a copy of it and whacked it on an advertisement. And they're like, this is a great photo of Oscar Wilde, let's sell stuff. And Napoleon said, well, wait a second, that's a bit unfair because I've got copyright in this. I made this, you can't use this without my permission, give me some money, what's going on? So he sued the company for copyright infringement. And the company said, no way, you just used a machine, you just pressed a button. This isn't your work, it's your camera's work. You can't copyright protect that, are you crazy? You just pushed a button. Supreme Court disagreed. The Supreme Court said, and I think this is quite beautiful, they found that Cerrone, because he had posed the said Oscar Wilde in front of the camera, selecting and arranging the costume, the draperies, and other various accessories, and arranging the subject so as to present graceful outlines, and disposing the light and the shades, suggesting and evoking the desired expression, and from such disposition, arrangement, and representation, it was made entirely by the photographer, and he therefore produced the picture. So he got copyright protection over that. Is there an analogy here? Can we compare AI-generated art to the photos that cameras make? Perhaps. So in the meanwhile, I've already said that it's a really complicated ecosystem. We don't really know what the judges and the lawyers and the policymakers and Joe Biden and Rishi Sunak and all the rest of it, and all the tech bros, what they're gonna do about AI. But I can tell you that there are a couple of things that we can do in the meanwhile to protect your brand, to protect your creative content. First is information gathering. Just by being here today, you're taking the first step. I know that sounds cliche, but it's absolutely true. Even Getty Images, they're doing a bit of soul searching. They're creating their own generative AI model. It's called Generative AI by Getty Images. It promises full indemnification for commercial use and is meant to avoid the IP risks that make businesses wary of using generative AI. So do some soul searching. Think about what it means for your brand. Do you want to use AI? Do you not? What do customers want? Do we want to use human skill as a unique selling point if the market's overcrowded with AI stuff? Okay. In addition to information gathering, practical protections. We saw what the watermark did for Getty. The other thing to consider, and I know this is a bit of a difficult one, it's that balance between publicity and protection. Do you really want to be uploading 100 pictures of one, thing on social media so it can be scraped? Or do you want to be a bit more sensitive about how much you're putting out into the ecosystem, onto the online ecosystem? Have to say this, revisit your contracts. Boring, it's okay, you don't have to revisit them. Give them to me, I'll revisit them for you. And then also be mindful of the fact that transparent disclosure regarding the use of AI is coming down the pipeline, and it is coming fast. So again, in terms of your brand, do you want people to know that you're using AI? They're probably gonna need to know sooner rather than later. And then finally, take legal advice. Doesn't have to be from me, doesn't have to be from my law firm. I would say don't go to Google for everything, but a good lawyer, we know more than just what's in the textbooks, okay? We do know what TikTok is, we do go online. We are trained to understand business risks and opportunities, and any good lawyer worth their salt will be able to tell you how you can or might not want to protect your rights. We have more than just a yes or a no stamp, I promise you. So I hope that this is giving you an insight about how complicated the ecosystem is. And yeah, would love to hear your questions. Thanks.
Great, thank you. Good. Whew. A lot of questions around that topic, I guess, I hope. Because I have to say, just after Nathan's talk, it's pretty important stuff.
Yeah.
It is. Should we start the questions? If we take the top one, are the creatives generated using synthetic art as inspirations, copyright protected?
I'm going to assume that's creations. So the answer is, in the US, no. In the UK, maybe, because the UK recognizes computer-generated things as maybe copyright protected. It depends. So if you're using it as inspiration versus if you're putting it on a side of a building, it doesn't really matter. The law is just considering, is it original, is it creative, is it tangibly expressed, has it been created by a human? So that's a very straightforward kind of question. Any major lawsuits among fashion brands?
May I ask you, just before that first one, because when we had the last Flow event in New York, we had a speaker who used Gen AI as well to create actual editorial campaigns.
Yeah.
And what he said was when they did their work, all of their work, they very, very precisely noted down what did they do, how did they prompt, when were humans involved, and all of that stuff.
Did they create the algorithm? So this is the issue, is that you don't know what the algorithm is actually trained on.
But his argument was that we can prove we had human involvement and everything else, and we can then...
Yeah.
What's your take on that?
My take on it is, it depends. No, but seriously, I'm personally of the view that in the same way that every photographer or great artist or great musician takes inspiration from different strands throughout history, and yet we still, like I keep returning to my son's finger painting, but I think it's a great example. That silly, dumb thing that he made is copyright protected. Why can a beautiful piece generated by Nathan and his AI helper, why can that not be copyright protected? So I would say that there are certainly arguments for copyright protecting things that you are generating.
Okay.
However, I feel like we need to have an appropriate model to remunerate those artists and creatives whose work has gone into the training data. So I can't speak for what the law might or might not say. I can say that at our current point in time in the United Kingdom, it depends on a lot of factors as to whether the piece is copyright protected.
Now, if I may, I'll jump to this one here. Are we moving to a digital watermark on images to guarantee authenticity? Because when I was up here introducing you, I saw a lot of faces nodding when I thought, okay, this is something that we're troubled by. Because right now we have a lot of people in this room that are generating content every single day, putting it online, it's being scraped and used by Stable Diffusion, Midjourney, whatever, to train their AI. Is there any way, that was a big discussion when I was at the conference in the US, to like opt out, saying, listen, you cannot use images on our website.
Yeah, you certainly can.
Right? And that's back to the watermark thing.
Yeah. The answer is digital watermarking on images to guarantee authenticity. Yes, that's something that people are working on. But what happens is that, what if you put the watermark on something that isn't authentic? Who's going to verify that for you? There's no computer program where you can, at the moment, where you can check if something actually is authentic. You're basically going on someone's word. Regarding the opt-out, that goes back to the contractual provisions that I mentioned earlier. There's no automatic super policy that regulates the entirety of the online ecosystem. What you could do is say, I'm going to opt out, and if I find out that you opted me back in without my permission, I'm going to sue you under X, Y, and Z clause in the contract. That speaks to the contract between the parties. So again, it depends on what's written down.
Okay, good. Then let's get back to the top one here. Do you know of any major lawsuits or any lawsuits among fashion brands due to AI-produced or generated visuals?
Not at the moment. They try to keep that stuff pretty quiet until the absolute last minute, because most fashion brands will want to settle out of court.
So what you're saying is it's probably out there.
Absolutely. It's probably out there. It'll become a matter of public record if the dispute cannot be settled before the court stage. So there are probably lots and lots of negotiations going on right now.
I can imagine. Yeah, I think there's a lot of stuff that is just about
pre-dispute litigation.
Yeah. Good. Oscar Wilde. In the Oscar Wilde case, it seems the qualities cited were based on art direction and set style. So if someone else hit the button, who gets the copyright?
So I can tell that a creative professional asked that question, obviously. Well, in that case, Cerrone was both the art director, was both directing it and pushing the button. Under UK as well as US copyright law, it's the person that pushes the button it's literally the person that pushes the button. Same way that when I go into a podcast, the person who hits record gets the copyright, but what they will do is they will have a contract sitting behind that saying, I'm pushing the button, but I'm assigning or transferring or licensing my copyright to my boss, to the studio. So depends on what the contract says, but at the end of the day, it's the person who actually pushes the button.
Good. Next one here. If we can get copyright on an AI-generated image, is there a risk that someone tried to create unlimited images and use those to sue others?
I'm not really sure what's meant by unlimited. Can the person who asked this question just find me at the break so I can answer it in a better way? But the answer is yes, there's always a risk. I mean, again, I think people sometimes think that just because the law says that you can't do something, people never do it. I mean, this is absolutely not the case. A lot of factors go into determining if the infringement happens and what you can do about it. So yes, there's always a risk.
Good.
Oh, yeah, this is a great question.
Yes, the top one here.
Yeah.
I put real models into AI-generated background scenes. Could that affect the copyright of the images as it has had more human input than just the code?
Yeah, so that's called transformative use, and it's something that the US Supreme Court has been dealing with regarding a photo of Prince, the musician. Andy Warhol took that photograph, and then he turned it into an oil painting. And the court was really confused because it was like, is this a copy? It's painting, it's new colors, the original was black and white. So again, you need more than just like, there's this myth that like, oh, if you change 3 aspects of a photo, it's not copyright. That's a myth. It happens on a case-by-case basis. They evaluate the purpose for the modification, the extent to which you made the modification.
Yeah, good. I'll jump to this top one here. Because I guess this could be one to the contractual side of things.
Yeah, absolutely.
But if we trained AI to use existing photo models for e-com, what's the policy in terms of payment? Do we simply pay them the same session and usage fee?
It depends on what the contract for the AI says.
Any recommendations on how we should handle those contracts?
So I always think that, again, first, I know it sounds so boring, but again, it goes back to the doctor analogy, right? Like, if you're not feeling well, don't Google, like, do I have cancer? Like just go to the doctor and let them do the blood work. Let me do the blood work for you. It really does depend on what the license terms are, but I would say that it usually comes down to usage fee and the amount of generations that you're creating that determine the business model.
Good. Yeah, I think we're having some questions.
No. Maybe, yes, Creative Commons licensing. This is a really good question. I appreciate we're almost out of time here, but if you're doing Creative Commons licensing, then the artist has opted in to allow the public to use the photo. It could potentially protect you from copyright infringement. However, there are about 7 different Creative Commons licenses. There are some that are no commercial use. So if you're using a Creative Commons license that says no commercial use, and you use it for commercial use, naughty, don't do that. So again, people think, oh, Creative Commons, this is great, I can use it, I can put it on the side of the bus. The terms for Creative Commons are very lengthy. So.
I have a question for you here at the end. Do you foresee that we, in a couple of years, 2-3 years, have like a common system, legislation, whatever, to actually for opt-in, opt-out, all of that stuff, but also to identify if something is actually authentic, that will go across like all digital assets, like both from news media, right, images, video, into what we do here that is more artistic and e-com and so on. Do you see us getting to that level at a certain time?
I'd love to believe that, but the cynic in me says that there are a lot of tech players out there and a lot of nefarious actors who don't want us to actually be able to know what's real and what's been augmented, and they're the ones who lobby Congress. So find me during the break and I can chat to you about that.
Good.
Thank you so much.
Thank you very much to Kelsey.